was approaching the ATM when Matthew Chavez and his girlfriend and co-conspirator pulled up behind them and attempted to rob Tyler. He made the mistake, frankly, of trying to rob a veteran of the armed services who was actually armed at the time that the robbery commenced. Tyler drew a weapon, as is his right to do, and attempted to stop not only the robbery but to detain Mr. Chavez. In the ensuing confrontation between the two of them, Matthew Chavez shot Tyler Lackey several times and killed him. My office at the time, the district attorney's office, took Mr. Chavez to trial and secured a conviction of second-degree murder, tampering, conspiracy, armed robbery, a number of other charges, and secured a 23.5-year sentence for Matthew Chavez. Subsequent to that verdict, an appeal was initiated by Mr. Chavez's counsel that made the, frankly, astonishing claim that Mr. Chavez's conviction should be overturned because he was entitled to a lesser included instruction of voluntary manslaughter. Most states in this country would never permit an armed robber and an initial aggressor to get a step-down instruction for voluntary manslaughter. The Attorney General's office took up that issue on appeal, argued the case before the Court of Appeals, and in a rather stunning decision reached by the Court of Appeals, they overturned that conviction of Mr. Chavez based on the fact that he had not received the instruction of voluntary manslaughter. The real challenge that we have, and the thing that frankly gets lost, is, you know, we're at 7 years now since Tyler's passing. The anniversary was, I think, just 2 days ago. And 2 days ago Sunday, 7 years. And this family's still waiting for justice. So, you know, I know that we made a complex presentation about the law and this piece of legislation, but I want everyone to understand that she's been living through this for 7 years, waiting for justice, waiting to see her son's killer held to account. And we need to always keep that foremost in our minds. Is, you know, we live in a criminal justice system that oftentimes elevates, frankly, and places a priority on the impact that the process has on criminal defendants, and utterly fails to recognize what it does to victims and their families. And that has to stop. So we are here today because the only avenue we have for making sure that this miscarriage of justice doesn't occur again is to introduce the proposed bill, which would preclude a violent aggressor or an armed robber to have the benefit of what is known as imperfect self-defense, and thereby get a lesser included instruction.